Mr. Seeger, is this Mr. Cross?
It is, Your Honor.
Okay. You and Mr. Cross would like to come to the podium. This is People versus Cross, case number 234875. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Seeger, appearing on behalf of Mr. Cross.
How did we want to proceed today, Mr. Seeger?
Your Honor, it's my understanding that Mr. Cross is going to tender a plea to count one. In exchange, the habitual offender fourth notice would be dismissed.
And Mr. Ziegler, is that a correct statement of the plea offer?
It is, Your Honor.
Mr. Cross, have you had a chance to talk to Mr. Seeger about this plea today?
Yes, sir.
And is that how you wanted to proceed as well?
Yes, sir.
You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. Mr. Cross, are you currently on any kind of probation or parole?
No, sir.
And you understand that by pleading guilty to this charge, which is possession of methamphetamine, the maximum possible penalty that you could face would be up to 10 years and or a $15,000 fine.
Yes, sir.
With that maximum possible penalty in mind, what is your plea to that charge today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights.
Yes, sir.
And you understand that you're giving up and waiving all of those rights by pleading guilty today.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal it or get it reversed, you would have to ask the next higher court up, the Court of Appeals, to hear your case. They could say no, and then that would be the end of any appeal. Do you understand that?
Yes, sir.
Has anyone threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we said here in court today?
No, sir.
Is it your own free choice to enter this plea?
Yes, sir.
Are you pleading guilty because you are guilty?
Yes, sir.
This happened on July 18th of 2023. Is that the correct date?
Yes, sir.
On that date, were you here in Kalkaska County?
Yes.
And while you were here in Kalkaska County on that date, did you have possession of some methamphetamine?
Yes, sir.
Did you know that that's what that substance was?
Yes, sir.
Did you have any legal right to possess any amount of it at that time?
No.
Thank you. Mr. Ziegler, are the people satisfied with the factual basis?
Yes, Your Honor.
Mr. Seeger?
Yes, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger?
Yes, sir.
Thank you, Mr. Cross. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. We'll set this matter for a sentencing hearing. You'll be notified of the date and time of that hearing. It's important that you stay in touch with Mr. Seeger prior to that so that you're prepared to go forward on that day. Before you leave today, you're going to meet with Mr. Bear up here to set up a pre-sentence interview. Mr. Ziegler, anything further on this file?
No, Your Honor.
Mr. Seeger?
No, sir.
Thank you, Mr. Cross. That's all for today.
Thank you.
Mr. Traxler?
It is, Your Honor.
People versus Traxler, case number 234878. The record should reflect that Mr. Traxler is present here in court. Put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Thomas Seeger, appearing with my behalf, Mr. Traxler.
This is the date and time set for a sentencing hearing in this matter. Mr. Traxler, have you had a chance to review the pre-sentence report and go through that with Mr. Seeger?
Yes, sir.
Mr. Seeger, are there any additions, deletions, or corrections to that report?
No, Your Honor. No challenges to score either.
Thank you. Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do people have any victims that wish to address the court today? Anything on behalf of the people for Alex?
Thank you, Your Honor. This defendant is a young man, became involved in for lack of a better term, a conspiracy involving a large number of thefts of certain personal property in the area. When he was caught by police at the time of the arrest, he was cooperative. He told the police where the generator they were looking for was. He's been relatively compliant with law enforcement. He's appeared at most, if not all, of his court dates. I do think he's a good candidate for Holmes Youthful Trainee status. I think it's appropriate given his young age and his relatively good cooperation with the arrest and the police questioning at the time of his arrest. So for those reasons, Your Honor, I would ask the court to adopt the recommendation, sentence him to Holmes Youthful Trainee Act, and give him an opportunity to demonstrate to the court that he still can reform his life and turn the situation he's found himself.
All right, thank you, Mr. Seeger.
Yeah, likewise, I would just ask the court to give him the benefit of HIDA. The only question was whether or not the court would impose any additional jail time. He did spend 43 days in jail currently, or at least that's what the citizen's report reveals. I did speak to probation parole about this particular file. I think Ms. Wagner had some reservations about initially conceivably giving him the benefit of HIDA because there have been some unsuccessful discharges, and he is somewhat accumulating in criminal history, which is concerning. But when the offer was made, all of these things were known to the prosecuting attorney's office. Part and parcel of the reason why the offer was extended was, one, because he was cooperative with law enforcement, and two, at some point in time, he did make a truthful statement relative to his involvement and maybe that of others. But be that as it may, Your Honor, I agree with Mr. Ziegler. He's a young person. He can learn from this. He does have a family to support. He has been doing much better, at least from the time that I initially had met him up until the date of sentencing. He has been in continuous contact with me when a lot of clients who, for whatever reason, they just don't see fit to reach out to me even when I'm trying to reach out to them. But he has been maintaining communication. He's indicated that he wants to try and better his life. Because he's young, I'm hopeful that he'll have an opportunity to go forward and do some things that are meaningful with his life. And maybe now that he has a child, he'll see the benefit to maybe a good day's work in terms of the responsibilities that he now has that maybe previously he wasn't thinking so closely about. I think that also distancing himself from maybe some other people who are causing him problems will be helpful to him. I have spoken to his mother, who has regularly contacted me, who does have good family support. I think that HIDA would be a good opportunity for him to ensure that he perfects his probation, and I guess to the extent that he doesn't successfully complete it, I guess the remedy is that he would conceivably lose that status and also be subject to jail. In some instances, Your Honor, I did tell the client this, that if the court were inclined to impose jail with the caveat that you receive the benefit of HIDA, there are many instances where the court will suspend the balance, but we'll hold the time in advance. And so if you violate your probation, the time is already imposed, for which you understood as well. He's just hopeful that he'll be able to get things straight. He's remorseful for what happened. And hopefully we don't see him again other than to just walk by him and say hello.
All right, thank you, Mr. Traxler. Anything that you wanted to say today?
Your Honor, I just want to go along with what they're saying. I just got into just a bad place in my life. I wasn't doing good. Right now, I have one child. He's one, and I have another on the way. Recently, I just actually got a job working at a restaurant just for some kind of money and to support my family. I'm trying my best. I'm just hopeful that you'll think about HIDA and just give me a chance. Thank you, Your Honor.
Okay, I did read through the report, so I'm familiar with what happened in this particular case. There's also a lot of information in there about your background, your prior record and so forth. And it is concerning that at age 19, you're starting to amass a fairly substantial criminal history. And it involves a number of different theft crimes. There's an R&O in there. So I think you're running out of chances. You know, the argument that you're young and these are youthful mistakes starts to become weaker the more you continue to repeat the same behavior over and over again, because that shows that the age isn't really a factor. You're just engaging in criminal activity. I do think that it's there's really no loss to the community in giving you an opportunity under HIDA. It puts all the burden on you if you want the benefit of that to comply with your probation, and if you don't, it just gets revoked. So I don't see that there's any loss to giving you an opportunity, and I think, you know, you still are 19. You still have a chance to kind of put things together here and get on the right path. So I don't have an objection to HIDA, and the court is going to put you on probation pursuant to HIDA. In terms of jail time, though, I think you need to do some time here. You've already had a 60-day jail sentence. You've already had some time held in abeyance, 90 days held in abeyance on one of the retail fraud. Those things haven't been effective in terms of correcting your behavior. And I don't see any reason to sentence you to less in this case than you've been sentenced to on previous cases. I think the principle of progressive punishments, as you understand, the more you continue to do this, penalties go up, they don't go down, it doesn't go in reverse. So the court finds that jail time is appropriate in this case, and jail time in excess of what you've already been sentenced to on different cases in the past. So the court is going to place you on probation pursuant to HIDA for a period of 18 months. The court is going to adopt all the terms and conditions listed in the report. So it's important for you to go through those with your probation agent once you're released, in order to make sure that you understand all the conditions of your probation. The guidelines in this case are 0 to 11. The court finds that a sentence in the middle of the guidelines is appropriate and accounts for your previous history as well as your behavior in this case. The court is going to sentence you to 6 months in the Kalkaska County Jail. You do have credit for 43 days served. The court is going to order that you pay a crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60, and a state cost of $68. You are also be required to pay a supervision fee while you're on probation of $30 per month. Mr. Ziegler, is there any restitution being requested?
Your Honor, the report indicates that probation reached out to the victim and he wasn't able to provide a number of restitution at this time. I would just ask the court permission to come back later with the restitution amount if we can get that number from the victim.
Okay, so the court will reserve restitution. The court will leave that to the prosecutor to file a motion for restitution if that becomes appropriate at some point. Because this is pursuant to HIDA, there are no appellate rights at this time. Mr. Ziegler, anything further we need to address here today?
There you go.
Mr. Seeger?
Thank you. Nothing further.
I can just say one thing. Sorry.
That's up to you.
I know you've already made your option and everything, and there's no going back on that. I just want to thank you for this opportunity. I just want you to know that I have a baby coming. He'll be born before I get out. I'm really trying to change, man. In the 90 days and the 60 days, I got everything figured out. This is the only county that I have anything over me. I'm really trying to figure out my life, man. My girlfriend's down with me. She don't even know. I just want a chance. I understand this county has gave me a lot of chances. And I'm just trying to better my life. I don't want to go down this road. I don't want to be sitting in jail with my baby born. You know, it's heartbreaking. I've been through this so many times. Just asking the court if there's any way I could hold in advance or anything. I'm trying to clean up my life, man. I really am. I'm supposed to have a baby gender reveal. We didn't have that for my last kid. It means a lot. And it's just, you know, I got a job now. I'm gonna lose my job doing this. I'm supposed to start another job docking and making more money, you know, supporting my family. It just breaks my heart that I can't be there for my kid and my girlfriend. Like, I'm supposed to be a man, and I haven't been the man in the house, you know. I haven't, like, look at my record. I have, you know, it's a bum. Like, you can't get anywhere in life. It's not who I want to be. I grew up looking at my peers like that's not who I want to be. You know, like, I don't want to be like everyone that I grew up around in my life. I'm just asking, please.
Yeah, so everything that you're saying, I get it.
I understand.
And it stinks, but what you should be doing going forward is, once you're done with this, the next time you're presented with the opportunity to engage in illegal conduct, you should think about this moment and think about everything that you're saying right now. And it should provide
I know what I
real
have, Your
motivation for
Honor.
you to not do it again.
I know, but this.
That's all. You're done. You're gonna go with the officer now.
I think my docket is concluded until 11, so I'll be there for 11.
Okay.
I think that came out.
Our next hearing is People versus Ross at 9:30, so we'll take a short recess. All right, Mr. Ianni, are you able to hear me okay?
I can, Your Honor. Hopefully you can hear me as well.
Yes, thank you. And the defendant's connecting in here, so 1 second. Mr. Travis, let's go on the record in People versus Ross. This is case number 244882. The record should reflect Mr. Ianni's present by Zoom on behalf of the people. We have Mr. Travis here in the courtroom on behalf of defendant Aaron Ross. I have an individual connected under Aaron Ross. They're not turning on their microphone or their camera. So Mr. Travis, have you had contact with Mr. Ross?
I just spoke to him this morning on the phone. He actually just got out and found it out last night, and so let me see if I can.
Oh, okay. Mr. Ross, can you unmute, please?
Yes, can you hear me?
Yeah, okay, all right, good. So we have Mr. Ross connected now. This is set for a scheduling conference hearing. I believe this is Mr. Ross' first appearance before circuit court in this file. Mr. Travis from the defense side, can you tell me where things are at?
Yes, Your Honor. We are in the process of working towards a delay deal, which is kind of standard in these cases. Mr. Ross, I believe yesterday, was able to post the bond. We had submitted an order relative to having that transferred to the FOC case. We had also submitted an order allowing him to go. He's from the state of Montana, has lived there for like the last number of years, was born and raised there. He did briefly live here in Michigan, and that's why this case is here. But he's posted that money, just getting out, heading back to Montana, going to get back to work, start making payments. But largely, I believe the AG wouldn't want to let us enter that deal because that money hasn't actually hit the FOC account. But our intention is once that money hits the FOC account and is where the AG wants to see it, it's Mr. Ross's intention to enter into a delay plea deal with the Attorney General and go forward that way. But I believe at this point, the AG is not quite, even though everything's happened as we hoped, it's not quite ready to enter the deal, is my understanding.
All right, Mr. Ianni, what's the people's position?
That's generally correct, Your Honor. As of this morning, the front of the court's report does not show the $6,000 bond payment as having been applied to the arrearage. The arrearage is around $23,000. The plea deal is once that's applied, the defendant will plead guilty as charged with a delayed sentence if the court will allow it. During the delay, the defendant would continue to make his monthly payments. And at the end of the 11 months, if he's able to reduce the arrearage down to $11,500, the people will amend the complaint to the information to allow him to plead guilty to an attempt. And if he's able to reduce the arrearage to 0, the people will amend to allow him to plead to a misdemeanor disorderly person. That is the general outline of the plea that we have on the table. The hangup right now is that because the payment was made last night, it hasn't yet been applied. I understand the court has signed the order, so we're willing to go on faith that it will all happen since the order has been signed and the money has been paid. So if the court wants to go ahead and take the plea, we're willing to take it on faith that that money will be applied shortly.
I don't know. I think what I'd rather do, Mr. Travis and Mr. Annie, is just set this for a plea hearing in about 30 days. Do you have any objection to that, Mr. Travis?
No, Your Honor, that's what Mr. Ross and I had discussed, because I appreciate the AG's reasonableness on this, but I didn't know that was what was going to happen.
Okay. So, Mr. Annie, do you have any objection to the court just setting this for a hearing at the court's next motion day and then taking the plea at that time?
Of course not, Your Honor.
Okay, so we'll do that. The court will send out notice of the date and time of that hearing. Mr. Annie, whether it's you or a different AG, the court would be happy to have you appear by Zoom if you want to do that. Just let the court know ahead of time. And then Mr. Ross, just make sure that you stay in touch with your attorney, okay?
Yes, sir.
For Mr. Ross. Mr. Ross, we also need, can we get a current address from you so that we can send you mailings from the court?
Okay, it is number 6 Walnut Grove Drive, Billings, Montana. And it is
You have a
59110. What's that?
Go ahead, sorry.
Okay, so yeah, it's number 6 Walnut Grove Drive, Billings, Montana, 59102.
Okay, very good. Thank you. That's all for this hearing today, and all parties are free to disconnect this time.
All right. Thank you, Judge.
Thank you very much.
All right, sir, in Sheboygan there, can you tell me your name, please?
Jessica Matson.
Miss Matson. Okay, Mr. Travis, are you ready on that file?
We are, Your Honor.
Okay, the court will call People versus Jessica Matson. This is case number 2348880. The record should reflect Miss Matson's appearing today by video from Sheboygan County Jail. If I could have counsel put your appearances on.
Brian Siegel on behalf of People, Your Honor.
Kyle Travis on behalf of Mrs. Matson.
This is set for show cause for failure to appear last month. And then status conference here today. So Mr. Travis, how did you want to proceed?
Your Honor, in speaking with Ms. Matson a few days ago, I think she would like to accept the prosecutor's plea offer. It's my understanding that it's an alternative offer. Either she could plead to 1 count of possession of methamphetamine with no enhancements, or she could plead to 2 counts of possession of narcotics, the 4-year. It's my understanding Ms. Matson would like to accept the 2 counts of possession of narcotics, the 4-year. Relative to her, I don't know if the court wants to get into her non-appearance last month or not.
Yeah, please, if there's an explanation for it.
The situation was Ms. Matson has ties up in Sault Ste. Marie, and she had recently gotten out of jail, and she found herself up in Sault Ste. Marie without a phone or a car. Unfortunately, when she was starting to correct that, she ran into law enforcement a couple days after our court hearing and was picked up on a warrant about just Sheboygan.
Okay. So she was lodged essentially.
A couple days after our court date. At the time of our court date, she was without an automobile or a phone, unfortunately.
Okay. All right. In terms of the plea offer, Mr. Ziegler, is that a correct statement?
It is, sir.
Okay. And as to the 2 possession charges, what's the substance that she's going to be pleading to?
Your Honor, I don't have a preference. The one that's charged is cocaine, so she could plead to 2 counts with a factual basis for cocaine, or she could plead to a possession of methamphetamine, and the court could take the second possession of narcotics under the court rule.
Okay, and then if it's the 2 4-year, were there 2 different types of cocaine? Where did it occur on 2 different dates, or where do we get the 2 charges?
Your Honor, I think that the legal underpinnings or rationale behind it is that she's evading a 20-year alleged possession with intent to deliver methamphetamine.
Okay.
And so that's essentially being reduced to the possession of narcotics, and then she'd be pleading to count 2.
Okay, so take a factual basis to cocaine and to methamphetamine.
I think that would probably make the most sense.
Got it. Okay. All right, Ms. Matson, have you been able to hear all of that?
Yes,
And is that what you'd like to do? Plead guilty to 2 4-year possession of narcotics crimes?
yes, Your Honor.
Okay, can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes,
Thank you. You can lower your hand. Ms. Matson, were you on any probation or parole at the time that these crimes occurred?
yeah,
You were, but was it probation or parole?
probation.
Okay, so you understand that,
It was probation in Kansas, Montgomery County.
all right, so you understand that by pleading guilty here today, that could result in a violation of your probation there, and that you could get some extra penalties for that?
Yes, I do understand.
Okay, counsel, are either of you aware of any potential consecutive sentencing sanctions here? Mandatory?
None that are mandatory. Your Honor.
None mandatory from Your Honor. I must say I don't know how things work in Kansas, but
Okay. Not under Michigan law?
yes.
Okay. All right, and Ms. Matson, you understand that by pleading guilty to each of these charges, that each of them carry a maximum possible penalty of up to 4 years and or a $25,000 fine?
Yes, sir.
With all of those things in mind, what is your plea to each of those charges today?
Guilty.
Right now, you have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand all those rights?
Yes, sir.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, sir.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to appeal this plea today or get it reversed, you would have to ask Court of Appeals, which is the next higher court up, to hear your case. They could say no, that would be the end of any appeal. Do you understand that?
Yes, I understand.
Has anyone threatened you with anything to get you to plead guilty?
No,
Has anyone promised you anything other than what we said here on the record today?
no,
Is it your own free choice to plead guilty?
yes,
Are you pleading guilty because you are guilty?
yes,
The information I have indicates that this occurred back on July 3rd of 2023. Is that about the correct date?
that is,
On that day, were you here in Kalkaska County?
yes.
While you were here in Kalkaska County on that day, did you have possession of some methamphetamine?
I had possession of narcotics, cocaine,
Okay, which narcotics did you have possession of?
cocaine,
Did you have possession of any other drugs at that time?
not that I'm aware of. From my papers, and I don't have all that paperwork with me.
All right, Mr. Ziegler or Mr. Travis, did you want to ask some additional questions?
Yes. So Ms. Matson, you had illegal narcotics on you. Were there other other groupings or other amounts of narcotics than just the cocaine in your possession?
Not that I'm aware of. No. I didn't see any of the evidence. I didn't see any evidence.
Ms.
don't
Matson,
know.
this isn't about the evidence, this is about what was going on. If we want to accept the plea deal, we're not talking about the evidence, we're talking about what you know and what you're pleading to. So
Oh,
the
yeah,
question is,
yeah.
was there other narcotics there than just one batch of cocaine?
Yes,
Okay, and you're pleading to possessing two counts of narcotics, meaning there were two different batches of narcotics, is that correct?
yes,
Okay, thank you.
Mr. Ziegler.
yeah, sorry.
I think we still need to establish what that narcotic was and whether she knew it was a controlled substance or not.
Okay, Mr. Travis.
So that other item, did you know that that was a narcotic?
Yes,
And you knew you didn't have a legal right to have it?
I didn't have a legal right to have it now.
Okay, did you think it was methamphetamine? Did you think it was cocaine? Did you think it was heroin? Did you have any idea what you thought it was?
I thought it was meth.
Okay, thank you.
I'm satisfied, right?
Okay, Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
There you are.
Mr. Travis.
No, you are.
Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Travis.
Yes, Your Honor. Thank you.
All right, Ms. Matson, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of this charge. The court will accept your guilty plea. Or these charges, the court will accept your guilty plea as to each. We'll set this matter for a sentencing hearing. Do you know how long you're going to be in Sheboygan there?
I have not had court here for a while. It's going to be the 13th and 15th. And I also have a probation violation in Traverse City that I have to deal with. But I'm pretty
Okay.
sure it's gonna be a little while here.
All right, so Mr. Ziegler, the court will ask that you prepare a writ for Ms. Matson to be transported here to Kalkaska for sentencing.
Yes, Your Honor.
Mr. Travis, anything further that we need to address today?
Nothing further, thank you.
Ms. Matson, do you have any
Oh,
questions?
Your Honor, I do apologize. Could Ms. Manson's bond be revoked?
Mr. Ziegler, any objection to that?
No, Your Honor.
Okay, if you can submit a stipulation in order with today's date, or we'll sign that.
Oh, I just wanted to ask. if there was any-
Okay.
or is it just-
It's 2 counts, so I had to count 3.
Okay, thank you.
Okay, thank you, Ms. Matson. That's all for today. The court's going to disconnect at this time.
I did have a question.
Sure, go ahead.
You guys, it's gonna be running a writ, right? So this is all gonna be running concurrent?
Right, your bond's being revoked, so you're gonna get credit and, yeah, I don't believe there's any consecutive sentencing sanctions here, so
Okay,
if there are, you'll be advised of that and you would likely be given an opportunity to withdraw your plea.
okay. That's all I had to
Okay.
ask.
All right, sounds good. Thank you.
Thank you.
And do you have Mr. McGuire here?
Your Honor, I don't see him in the courtroom. I don't see him out on the hallway. I will go look around and give him a call.
Okay, we'll call that case in a little bit. Take a short recess and come back on the record in about 5 minutes. Mr. Aguero. The court will call People versus Elijah Aguero. This is case number 234860. Executive counsel put this here.
Ryan Ziegler on behalf of the people, Your Honor.
Morning, Your Honor, Marie Vandenberg on behalf of Mr. Aguero.
Mr. Aguero, I'm going to have you go right to the podium there, around the back. Record should reflect Mr. Aguero is present here in the courtroom today. I did receive a number of character letters on behalf of Mr. Aguero this morning. I had a chance to review those prior to the hearing today, so both counsels aware. And Mr. Aguero, have you had a chance to go through the pre-sentence report and talk to Ms. Vandenberg about that? Ms. Vandenberg, are there any additions, deletions, or corrections that need to be made to that report?
Your Honor, I spoke, yes, there is, Your Honor. I spoke with the prosecutor as well with regard to the scoring. So our challenge is to the scoring of OB3 at 25 points. We believe that should be 0.
Okay, hold on 1 second. Are you objecting to the change in scoring?
I'm actually not, Your Honor.
Oh,
It's
okay.
improperly scored.
Okay, so OB3 is scored at 25, and what should it be scored at?
0.
And Ms. Vandenberg, that's what you're asking?
That is what I'm asking, Your Honor.
All right, so that's a significant reduction in the OB score. That leaves us with 15 then, and where does that leave us with the guidelines?
We believe the guidelines to be 0 to 17. 17 minutes.
I agree, Your Honor.
0 to 17, okay. And so the court will order that those changes be made to the SIR to reflect a 0 to 17 guideline range. Any other changes, Ms. Vandenberg?
No other challenges, Your Honor.
Okay, are there any additions, deletions, or corrections to the report itself?
Your Honor, Your Honor.
Oh, Mr. Ziegler, do the people have any additions, deletions, or corrections?
Your Honor, on page 3, there's 2 lines of victim impact statement at the bottom of the page. It says writers Brandon, she and the defendant are parents of Joel. I believe that should read deceived. Parents of Joel.
Okay, any objection to that change, Ms. Vandenberg?
No objection, Your Honor.
Okay, any other corrections?
No, Your Honor.
Do the people have any challenges to the guidelines?
Other than the change that's already been reflected, no, Your Honor.
Do you have any victims that wish to address the court today?
I do, Your Honor. Miranda Brandon would like to address the court.
Okay, so Mr. Aguero, if you can have a seat next to your attorney there, please. Ms. Brandon, if you'd like to come forward. And can you just state your name for the record?
My name is Miranda Brandon.
And what's your relationship to
It's
the?
in my letter.
Okay, but can you just tell me for the record?
We are co-parents and best friends.
Thank you. Please proceed.
To whom it may concern, I am Miranda Brandon. I've known Richard Jeffers, the victim, for almost 20 years. We were best friends and co-parents of 3 beautiful children of 14, 12, who found the victim, and 8. 2 of my kids' birthdays were 2 months after the incident, and Christmas was 6 months after. If it wasn't for my children's school, they wouldn't have had Christmas. But it's not just about birthdays or the Christmases. It's about all the other important dates in their life, like graduation, marriages, and grandbabies. There's not a sentence long enough to bring back the kind, loving, caring person that we have lost. Thank you.
Thank you. Any other victims, Mr. Ziegler?
I don't believe so.
Anything on behalf of the people, Mr. Ziegler?
Your Honor, this is a case where the defendant delivered controlled substances to Richard Jeffers, which caused his death. The investigation revealed that the defendant, Elijah Aguero, had been very active in dealing controlled substances, both in this community as well as other areas. Specifically, it showed that the victim and the defendant had had a conversation shortly before the victim's death, where the victim was looking to obtain some boy, which is drug slang for heroin. victim later died and blood testing showed that he died of fentanyl toxicity. The court is likely all too familiar with these facts, as fentanyl has become something of an epidemic in our community. And it seems like every time there's a delivery causing death case, it's a case where the victim believed they were buying heroin, but instead took fentanyl and died due to that substance's severe toxicity. On the positive side, in this case, Your Honor, the defendant's a young man. He has time to reform his life. He has no prior record, and he did not intend to kill anyone. However, on the negative side, he is clearly a serial drug dealer. He has other pending charges for delivery. I believe that's out of Benzie. He either knew the substance he delivered was fentanyl, or at the very least, he did not know or care whether the substance was heroin or fentanyl. His behavior has caused the death of at least one person. He is richly deserving of punishment in this case, Your Honor. Unfortunately for all of us, his guidelines in this case are somewhat low, in my opinion. He has no PRVs. He has very few OVs. While the plea agreement did not call for a sentencing cap, it did call for the prosecution to recommend a sentence within the guidelines range. While the guidelines are low for the severity of the offense, I do believe they take into account most, if not all, of the relevant sentencing factors, as OV3 specifically instructs the court not to score for the death of the individual. And his other drug dealings do not relate to the sentencing offense, except as to show his mental state. Since the guidelines are presumptively reasonable, Your Honor, I would recommend a sentence within the guidelines. And since the crime resulted in the death of the victim, and since the crime was the result of an intentional course of conduct by the defendant involving distribution to many persons, I would ask the court to sentence the defendant to the highest possible sentence within those guidelines. Thank you.
Thank you. Ms. Vandenberg, if you and your client would like to come back to the podium.
Yes, John.
And Ms. Vandenberg, anything you'd like to say on behalf of your client today?
Yes, thank you, Your Honor. Your Honor, Mr. Aguero is a young man. He was 17 years old at the time of this incident. He's now 18. He's been incarcerated in the Antrim County Jail for about 170 days. So he has had a lot of time to reflect on the behavior that brought him before this court. He has had a lot of time to think about his future, the fact that he was on a wrong course. And when I say that, on a wrong path, this young man has a very loving, caring family. His mother is in the courtroom, his mother's fiance, and his two siblings are in the courtroom. As the court stated on the record, the court has reviewed 5 letters in support of Mr. Aguero. And the letters, they all have one common theme, and that is this is a kind young man, caring young man, a very helpful young man to his family, to his grandparents who wanted to be here but were unable to due to their health. He has a community of people that love him, that cherish him, that want to see him do better. And I've had many conversations with Mr. Aguero, and one of the things, Mr. Aguero, that struck me is the fact that he's remorseful, he's sorry. He didn't mean for any of this to happen. And he appears to be a serial, or at that time, a serial deliverer of drugs, but that wasn't the case. I think he was influenced by people that he should not have been around. When he is released from incarceration, I believe that this young man will be a law-abiding citizen. And it's not, I don't say it lightly, Your Honor, I don't, and I know the court has heard it all, but he has such a bright future. He plans to go back to school, get his GED, he plans to then advance education. He aspires to own his own business, to help his mother with his siblings. His mother lives in Waterford. He needs to get out of the community that he was in prior to being incarcerated. And I'm not blaming anyone but him. And he's taken full responsibility. He feels so horrible what happened to this family, and the family apologizes. I just don't, he's not a bad person. And I think given the amount of time that he has been incarcerated, he has had opportunity to think about what he's done and to say to himself and to his family, to this court, that he will never be before another court on a felony matter. And he said never. And I said to him, what are your plans? What are you gonna do? How are you gonna keep yourself out of trouble? Get out of the community, get out of Muskegon. I mean, there's drugs everywhere, but there's an abundance of drugs, there's abundance of gangs in that area. And this young man just doesn't need to be a part of any of that. And he can live with his mother. His mother has said he's more than welcome to come home to her and to his siblings. And that's what he's planning to do. And Your Honor, I don't, a person died, and that's a horrible thing. A life was cut short. A life that someone loved. He had children, children, a significant other, people who loved her. And Mr. Aguero doesn't take that lightly. He is truly remorseful, and he'll speak to that remorse and how he feels and what his plans are. And he's just asking the court to sentence within the guidelines. I would ask for a county cap, and I know that sounds horrible, given that a person died, but I believe that this man deserves another chance. And I'm asking the court for that opportunity for Mr. Aguero and for his family. Thank you.
All right, thank you. Mr. Aguero, anything you wanted to say today?
Yes, Your Honor. I would like to read this letter. I wrote a letter to the courts. I referred to the family, sincerely send my condolences for this hard time they are going through. They have been in my prayers. I just wanted to say that I'm not a statistic. I have aspirations to become a young, successful entrepreneur and going to college to get a degree in business. My mother is willing to allow me to move with her in Waterford, Michigan, to help me progress towards my goals. I was raised by a hardworking Christian family that just wants the best for me. I just asked the courts to give me one opportunity to show you guys that I truly have aspirations and goals I plan on accomplishing.
All right, thank you. I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your background and your circumstances based on that information in that report. As I indicated, I also did read through the letters that were provided on your behalf. Ms. Brandon, I also want to thank you for making a statement this morning. I appreciate what you had to say. Obviously, that has an impact on the court as well, along with all the other information. Along with what both the lawyers had to say. And obviously this is a very tragic circumstance, and whether you intended the death to occur or not, you certainly intended to sell the drugs to this person. And fentanyl is an incredibly dangerous substance. It frequently results in overdoses. Part of the problem is people don't know what they're getting, and maybe you don't know what you're selling. And they're taking the substance voluntarily, and you're certainly selling it voluntarily. And I agree with what Mr. Ziegler said. Either you don't know what's in it, or you just don't care because you want to make some money and accomplish your own ends. You don't really, at the time, care what happens to the people who get the drugs that you're selling to them. And unfortunately, frequently they do have deadly levels of other substances in them. And when that happens, you bear the responsibility for that because you're the one who engaged in that conduct. And some mistakes carry with them heavier consequences than others. And this is that kind of mistake. I am satisfied based on the information in the report that this wasn't like a one-time sale. You were actively engaged in selling drugs in this community. And so you're voluntarily accepting the consequences that come with that activity. You didn't have to do that. That's a choice that you made. You could have chosen to stop doing that at any time, and you chose to continue to engage in that conduct. And it resulted in the death of another person. So I think there is a consequence that has to be paid for that. Your age, your lack of any serious prior criminal history, limits the consequences that you're going to pay. And what that means is that you're going to have an opportunity in a relatively short period of time to seek out those opportunities that you indicated and that your family indicated in their letters that you want to pursue. So, you know, you're going to pay some consequences here, but you have an opportunity to move forward from this, and it'll be up to you as to whether or not you actually do get away from those bad influences, whether you do actually make some better decisions going forward. all that's gonna be on you and time's gonna tell. And I hope that's the direction that you take things, because you are a young man and you do have a lot of time to go in the right direction, regardless of the wrong direction that you've chosen to go into as of now. All of that being said, I do think that a sentence at the high end of the guidelines is appropriate. I think it's necessary to impose a degree of punishment on you, some consequences to you, and also as a deterrent effect, so that you understand that if you continue to engage in this conduct in the future, the penalties are only going to get more severe from here. So the court is going to sentence you to 17 months to 15 years in the Michigan Department of Corrections. You do have credit for 170 days served. The court is going to order that you pay a crime victims assessment in the amount of $130, court costs of $325, the DNA testing fee of $60, and state costs. You do have the ability to seek an appeal of this sentence. And the officer is going to provide you with your appellate rights. You can have him initial those. Let me know once he's acknowledged.
Yes, no.
Mr. McGuire has signed a notice of right to appeal.
Mr. Ziegler, is there anything else that we need to address?
Nothing further. Your Honor.
All right. Mr. Aguero, you are remanded to the custody of the state at this time. Mr. Morris present, is he lodged?
He is in holding right there. Yes, sir.
On record in People versus Morris, this is case number 234863. The record should reflect Mr. Morris is present here in the courtroom today. This is the date and time set for sentencing. If I could have counsel put your appearances on.
I'm Ziegler, on behalf of the people, Your Honor.
Michael Horowitz on behalf of Mr. Morris.
Mr. Morris, have you had a chance to go through the pre-sentence report?
I have, Your Honor.
And have you had an adequate opportunity to speak to Mr. Horowitz about that?
I have, Your Honor.
Mr. Horowitz, are there any additions, deletions, or corrections to that?
No, Your Honor, thank you.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
So, Your Honor.
Any challenges to the scoring? Anything on behalf of the people for allocation?
Your Honor, I have very little to say on this matter, largely because Mr. Morris's sentence is likely to be controlled by his next sentencing in about 10 days, which the court is well aware of. But in terms of this offense, Mr. Morris has a lengthy criminal history that I'm aware of. His guidelines range are 10 to 23. I think the recommendation in this case for an MDOC sentence is appropriate, given his history and given the pending matter in the other county. So for all of those reasons, Your Honor, I would just ask the court to give him a sentence to the Michigan Department of Corrections. And like I said, his ultimate sentence will be controlled by another county.
Thank you. Mr. Horowitz, anything on behalf of Mr. Morris today?
Your Honor, I can't disagree with what Mr. Ziegler had to offer. Mr. Morris's record kind of speaks for itself. It's noteworthy that there's no offense variable score. I think it's relevant. Of course, that sets a range, so nothing that we could spend a lot of time on. His PRVs are at the high end based on prior record. I don't want to say that we chuckled going over it earlier, but we did note that there were very few misdemeanors, scored 2 points on PRV 5. But that said, it is what it is, and it's a simple possession case, and we know that there's other cases out there that he's gonna have to pay a significantly higher penalty for. So we'd ask for just both returns. Possession is in front of you today, and I think that the guideline sentence is appropriate. Probably gonna end up doing significantly more than that for the other cases.
All right, thank you. Mr. Morris, anything that you wanted to say?
I'll say
Okay, I did read through the report, so I'm familiar with what happened in this case. Council's right, you know, the crime itself here wasn't particularly egregious. You were, it looks like part of a traffic stop and found with some methamphetamine. Which is, you know, certainly a violation of the law, but there's no indication based on this circumstance that you were engaged in delivery or anything other than personal use. Problem comes in, as you're aware, with your previous history, and that affects the guidelines. However, looking at things as a whole here, what happened in this particular case, I think a sentence in the middle of the guidelines is appropriate. The guidelines here are 10 to 23. The court is going to impose an 18-month sentence in the Department of Corrections. I think that addresses the problems with your past history, but also recognizes that this wasn't a particularly serious offense in this particular case. So the court, again, is going to sentence you to 18 months to 10 years in the Michigan Department of Corrections. Because you were on parole at the time, you're not entitled to credit, and this sentence must be made consecutive to any sentence that you receive as a result of the violation. The court is also required to impose a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a state cost of $68. So you do have the ability to seek an appeal of this sentence, and Mr. Horowitz, if you can have Mr. Morris acknowledge receipt of this appellate right now.
Your Honor, we've received the notice of appellate rights, and we are signing one of them. Yep. Received one. It's been executed, Your Honor. It's received. Acknowledged.
All right, thank you. Mr. Ziegler, is there anything else we need to address to the record on this file today? Mr. Horowitz, anything further on this file today?
No, Your Honor, thank you.
Mr. Morris, you are remanded to the custody of the state. Thank you going forward. Mr. Travis, I'd like to recall People versus McGuire. This is case number 234847. If I could have counsel put your chances on it.
Brian, so you want the people, Your Honor.
Kyle Travis, I'm the action, Mr. McGuire.
This was set for 9:45 this morning. It's now 10:30. Were you able to make any contact with Mr. McGuire?
Unfortunately, I was not.
Is it possible that, I'm just looking at the file here. It looks like the last. He's not lodged, is he?
He is not, Your Honor. Normally, I've been able to talk to him on the phone. His phone appears to be ringing, but gives me an available message when it hits the voicemail portion. Doing that yesterday and this morning. So I'm not, I don't have the information. He's appeared to a number of court dates.
I just asked because the last order I have in the file is from January 24th, with the court order that he be held based on a revocation of bond in Kalkaska County Jail. So,
Your Honor, to my knowledge, he's never been picked up on that ex parte.
oh, he hasn't been arrested yet. Okay.
Not to my knowledge, Your Honor.
Okay. So do we have an active bench warrant now? Show that bench warrant. court sign the order revoking bond, but I think maybe we need to issue a bench warrant. Last.
Your Honor, given the fact that he has, I think this is the fifth OWI offense, as well as the fact that based on my ex parte motion, that there were a number of positive and or missed tests by the defendant, and given he did not appear today, I would ask the court to issue bench.
Okay, the court will sign that once that's presented, and we'll proceed further with Mr. McGuire's case once he's arrested and brought before the court.
Thank you.
Okay, thank you. Next hearing is set for 10:30. Mr. May, is your lawyer here yet?
I believe he's gonna appear via Zoom, sir.
Oh, yeah, okay. He hasn't signed in yet, so we'll just take a short recess and then we'll come back on the record in about 5 minutes.
Yes, sir.
There we go.
All right, Mr. Isles, are you able to hear me okay?
I am, Your Honor.
Okay. All right, we're on the record in People versus Thomas May. This is case number 234826. The record should reflect Mr. May present here in the courtroom. His counsel, Mr. Isles, is present by Zoom video, and then we have Mr. Ziegler on behalf of the people present in the courtroom. This is set for sentencing in this matter. Mr. Isles, can you just kind of give me a refresher on where we're at with this case? I know there was some issues with sobriety court. Are we ready to proceed with sentencing today?
We are.
Okay. And is sobriety court part of it, or has that been determined that that's not available?
No, it's available. In fact, he's been attending for over a month.
Okay, good. Mr. May, have you had an opportunity to speak to Mr. Isles about the pre-sentence report and go through that with him?
Yes, sir.
Okay. Mr. Isles, are there any additions, deletions, or corrections that need to be made to that report?
A few small ones, Your Honor. On page 1 of the evaluation and plan, third paragraph, last sentence indicates that he first obtained his first OWI in 2007. That should actually be 2003.
Mr. Ziegler, any objection to that? Okay, we'll make that correction. Next one.
Well, Your Honor, on page 4, under defendant's description of offense, for some reason, there's a Martina that is referenced here, and there was no Martina involved in this matter. It probably was somebody else, and it just got typed in as Martina. Nothing that I'm talking about changes the value of this PSI. It reflects the woof and weave of the police report, and I think it's very accurate. There's just some minor spelling errors and things like that that I'm not going to go over.
All right, if we just change that to, instead of Martina, to another individual, is that adequate?
Yeah, that'll work.
Any objection to that, Mr. Ziegler?
No, Your Honor.
Okay. All right, Mr. Isles, then any challenges to the scoring of the guidelines?
No, Your Honor.
Thank you. Mr. Ziegler, do the people have any additions, deletions, or corrections?
Likewise, Your Honor, just a minor correction on the face sheet. The sentencing date still reads 2/6/2024. This should be corrected to today's date.
Okay, we'll correct that to 3/5/24. Do we need to change the jail credit? You know, Mr. May hasn't been launched. Okay. All right. Any other corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Do you have any victims that wish to address the court today?
No, Your Honor.
Anything on behalf of the people for allocation?
Your Honor, this is the case where I think Mr. May would admit he made some mistakes, and those mistakes were largely due to alcohol abuse. He has been working with the sobriety court case manager for some time now. I believe he is motivated to get his alcohol issues under control. I think the sentence to sobriety court will be good for him. I think it's worth giving him the opportunity to work through those issues and hopefully resolve some of the underlying problems that led to what was ultimately some very concerning behavior in this case. But I've had many people on the sobriety court program. It's a good program. Many people go through that program and resolve their issues and do not have any further recidivism. And I'm hopeful that Mr. May will be one of those people. So, Your Honor, I would ask the court to accept the recommendations contained in the PSI, sentence Mr. May to the sobriety court program. Thank you.
Thank you. Mr. Isles, anything on behalf of Mr. May today?
I could not possibly have put it any more eloquently than Mr. Ziegler did. Thank you, Your Honor.
Thank you. Mr. May, anything that you wanted to say today?
I think that sobriety court's a great opportunity that I'm extremely grateful to have the opportunity to be a part of, especially in my situation right now. So I just want to thank everybody that's been involved in getting me to that point, was able to do that and have that opportunity. So I think that'll be all, sir.
Okay. All right. I did read through the report, so I'm familiar with what happened in the circumstance, as well as your background and history. And this is a really concerning incident. You mix alcohol and firearms, and rarely does that end up well. And so I hope that you recognize that, number one, you don't want to combine those two things. Number two, you're probably better off just staying away from alcohol regardless. Because if it's going to put you in a position where you're going to engage in this kind of conduct, then it's not going to end up well. This, I think everybody's lucky this wasn't worse, but the next time might be. So we don't want to get to that next time. And I think by participating in the sobriety court, that's going to give you the kind of tools and information that you're going to need going forward to avoid doing that. So I hope that you are successful. It is a good program. It's certainly not easy, but I think benefits to you, if you successfully complete it, are definitely there. And the benefit to the community is obvious. If you're not using alcohol and not getting yourself into trouble, we're all a lot safer and a lot better off. So a lot of benefits to it. If you fail to do that, I'm going to impose some jail time and hold that in abeyance. So there'll be a consequence to you in terms of having to serve some jail time if you don't successfully complete it. And hopefully that's a motivating factor, but hopefully more motivating than that is just your desire to move on.
Yeah, it's time to do something different in life.
Yep, exactly. So the court's going to follow the recommendation as to the assault and battery charge at count 1. The court's going to impose a $53 state cost. As to the operating while intoxicated, count 2, the court is going to sentence you to probation for a period of 24 months. The court is going to adopt as the conditions of the probation all the terms and conditions listed in the report. Most important of which is that you participate in and successfully complete the sobriety court program. The court is going to order that you serve 8 months in the Kalkaska County Jail. You have credit for a 3-day serve. The court's going to hold that time in abeyance. So again, Mr. May, if you successfully complete your probation, you'll never have to serve that time. If you don't, though, then the court can impose any or all of that time immediately. The court is also going to order a court cost of $325, a $68 state cost, crime victims assessment of $130, and a $100 fine. The court will also impose any fee required by the sobriety court program. You do have the ability to seek an appeal of the sentence, and Mr. May, we're going to provide you with some paperwork that explains to you what your appellate rights are, as well as how to request help you with an appeal. Mr. Ziegler, I wonder if you would just be able to help him initial in the correct spots there, since Mr. Isles is not physically present. So.
Date. So saying you receive those appellate rights.
Yeah, you get those, sir.
Agent Barrett, does he need to meet with you today?
For the record, filled out the appellate rights form.
All right, thank you. So Mr. Mayor, I'm just gonna have you meet with Agent Barrett here for a little bit. Other than that, good luck to you going forward, and I look forward to signing a successful discharge.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Isles. That's all for today. You're free to disconnect at this time. Great. Mr. Horowitz, were you ready on Mr. Glarno's case?
Yes, sir.
Okay. People versus Glaro, case number 224645 and 244885. The record should reflect Mr. Glarno's present here in the courtroom today. If I could have counsel put your appearances on.
Brian Ziegler, on behalf of the people.
Michael Horowitz on behalf of Mr. Glaro.
Mr. Horowitz, this is the new file set for a status conference today, as well as the old file. Can you just give the court an update on where we're at and how you'd like to go forward?
Your Honor, I think the matter needs to be held over adjourned because my understanding is that there's 2 new charges filed. Probably an arraignment pending. Mr. Ziegler can correct me if I'm wrong on that.
Your Honor, we had just filed an amended information on the most recent charge. So there will be some additional counts.
Okay, that's the 2-4 file here.
Yeah, it would be the 2-4 file, Your Honor.
Oh.
There were a number of additional counts that I'm going to be adding. I don't know if that's made it to the court file yet or not.
It looks like it did, yeah, so. All right. So, Mr. Horowitz, you're just asking for some time to go through that with your client and discuss how to proceed.
Yes, Your Honor.
Oh. In light of the recent amendment, it looks like that was just filed on March 4th. I don't think that's unreasonable. Mr. Ziegler, do you have any objection to that?
No, Your Honor, and I think it would make sense to give Mr. Horowitz some time to discuss that with his client and then give Mr. Horowitz and I an opportunity to potentially reach a global resolution across these files. So I would ask that they both be adjourned out to the same date.
Okay. Mr. Glaro, do you have any objection to that?
No, sir.
Okay, so we'll set this for another hearing about 30 days out. And Mr. Glaro, it's just important that you stay in touch with Mr. Horowitz between now and then, okay?
Yes, sir.
That's all for today. Thank you.
Thank you, Your Honor.
Do we have Mr. Alexon present? People versus William Alexon, case number 224708. We have to reflect Mr. Alexon's present here in court today. If I could have counsel put your appearances on.
Ryan Ziegler, on behalf of you, Your Honor.
Thomas Seeger, appearing with and on behalf of Mr. Alexon.
William Alexon, defendant.
Thank you. We're on the record for a probation violation hearing today. Mr. Seeger, how did you want to proceed?
Your Honor, we were going to ask to continue the probation violation because we had previously adjourned it in lieu of the case that's pending in Crawford County. Or attend the attorney of record. I think you're the judge on that case, Your Honor. In any event, Your Honor, I think that except for status conference somewhere in the very foreseeable future, where either we will resolve that file with a plea of some sort, or in the alternative, we'll proceed to trial, at which point if he enters into a plea, presumably that will suffice for the probation violation or would be a factual basis for it. Or an alternative, if he's acquitted at trial, then I guess the court may look at it differently.
Okay. Mr. Ziegler, any objection to the adjournment?
No, Your Honor.
Is this you, Ms. Agent Vera? No, Ms. Wagner? Ms. Wagner, do you have any objection to what we're discussing?
I have no objection, Your Honor. I told Mr. Seeger, it sounds like he's coming up for court again in Crawford County on April 5th for I think it's for a jury status conference. And then his trial will probably be scheduled sometime after that. So I'm in agreement with everything.
All right, so we'll set this for a hearing in 60 days and let's see where we're at that point, and then we'll go forward from there. Mr. Alexon, just make sure that you stay in touch with Mr. Seeger, okay?
Yes, Your Honor.
Thank you. Okay. Ms. Wagner, anything else we needed to address on this today from your side?
No, Your Honor.
No. All right, Mr. Seeger, anything further?
Yes, sir.
Thank you, that's all for today. All right. Next case is People versus Yoder, case number 244884. You know, Mr. Yoder's lodged, or have you had any contact?
Mr. Yoder was here the other day for an unrelated matter. Me and states mixed up, so I didn't talk to him. I did talk to him about his file and talked to him about court dates. In any event, speaking with the prosecuting attorney, he has a new file that was generated, for which I think that we're going to attempt to, if we're able to resolve the files, they would all be wrapped together. He doesn't really have a history of non-appearance. It's just, I think he may have thought that yesterday was court.
Okay. That new file, has that been charged yet? Has he been arraigned on that?
He was arraigned yesterday, Your Honor. It's a high DHC and a minor in possession of alcohol in a motor vehicle.
Okay. Any sense on whether that's gonna be weighed up or?
They're misdemeanors, yeah.
They're misdemeanors, Your Honor, but I
Oh.
think that we would package them all together to the extent that, and then the case itself is likely to resolve. And when I last spoke to the client about it yesterday, it sounded like we're going to resolve the file.
Okay. I don't see any prior failure to appear from Mr. Yoder on this file. Sounds like he's had regular contact with his counsel, so the court will set this for a show cause and plea hearing in about 30 days. And we'll go from there. Any objection to that, Mr. Seeger?
No, sir.
No, you're right.
Thank you.
And Your Honor, I'm not sure if Mr. Broker is going to appear from the jail or not, but I mean, if he is, that's fine. If he's not, dispense with it.
I don't know.
Mr. Ziegler seems to think that he's maybe going to appear by Zoom, but
And I believe he's in our custody in Antrim County, and I don't believe he was physically brought.
Okay. So
That's my understanding.
if you guys want to call Antrim and see if they can get him on earlier, I'd be happy to take that matter.
Yes, he's in Wexford according to our sheet.
Oh,
I didn't do a reform.
oh, gotcha. Okay.
so yeah, I mean, I'm ready to go on that whenever you guys
I'm
are.
ready whenever.
Yeah.
I can try and call the jail, Your Honor, and see if, do you have anything else? I didn't look at my docket other than that.
No, this is my last thing in the morning. So.
Let me see if I can get a hold of the.
All right, let's take a recess. We're on the record now in People versus Broker. This is case number 224705. The record should reflect Mr. Broker is present today by video from Wexford County Jail. If I could have counsel put your appearances on.
Brian says we're the people, Your Honor.
I'm Seeger agreeing with an FAF, Mr. Broker.
Okay, Mr. Seeger, this is your motion. I don't know if the parties have received this. I'm in receipt of a recent evaluation dated February 27th, 2024. That's in the file.
I'm not sure I received that correspondence, John. If there was correspondence, I'm not sure I received it.
I received it this morning, Your Honor.
All
I
right.
just had an opportunity to read through it.
Looks like it was just filed with the court yesterday. It's dated February 27th, and it relates to the most recent evaluation. It looks like Forensic Institute had Forensic Center had an interview with Mr. Broker on February 27th. And their opinion as of February 27th is that he remains incompetent. I don't know if that affects your motion today or not.
Well, Your Honor, I guess it really doesn't particularly affect my motion per se, Your Honor. I am familiar with the court rule, and I did discuss it with Mr. Ziegler, but I guess my larger concern is, at least it's been my experience in the past, wherein somebody has been determined to be incompetent, that they essentially will take them to the forensic center and they will attempt to restore them to competency. And so the only service, at least as far as I'm aware of, that they provided to him is none. Like they may have reevaluated him, but ordinarily they'll attempt to restore you to competency, where you'll do some classes, they'll ask you questions, etc. For which they've not afforded him any of those opportunities to attempt to restore him to competency. So I don't know what it is that they specifically did. But I guess because there's been so much time that has passed, I'm just a little bit concerned that he's not able to post his bond, despite their findings that he's not competent at this time. And speaking with Mr. Broker, he had indicated that he wished to proceed to trial, which I can't do while he's currently determined to be incompetent. There was an offer that was extended to him at one point in time where he could plead to an attempt, together with a domestic violence charge, for which he's denying is untrue. And again, he wishes to proceed to trial, but I'm just at a little bit of loss because he just can't let this case linger without the forensic center doing something. If he continues to be incompetent in perpetuity, then I guess we'll have to look at some other remedy. But I guess just so much time had passed, Your Honor, where he's not been able to post his bond, I felt like I needed to at least let the court know that I didn't feel as though the forensic center was doing what I felt they needed to do, and there was an order wherein he was determined to be incompetent, so I felt as though he should be taken there for further work. Yes.
All right, Mr. Ziegler.
Your Honor, I assume the court has read my motion. Largely, I would rely upon that. I don't think there's any court rule that allows for the relief that the defense is requesting. In fact, specifically, that rule denies that relief. Similarly, the statute denies that relief. I would also note, just as new information, Your Honor, I believe it was yesterday, Mr. Soller we had a competency status hearing on him, and he was recently transported to the forensic center. He's been in our custody for a lengthy period of time, I want to say several months. And he was recently transported to the forensic center. So it's not like the forensic center is just wholly abandoning this county or has forgotten about this county. I believe they legitimately are lacking beds to deal with the volume of people that are in need of treatment. I would also note, and although I understand Mr. Seeger has not received this, but in terms of the report that we received, Mr. Broker appears to still be under some delusions and some concerning behaviors, at least as of February 27th, as detailed in that report. So in terms of my arguments relating to his release, if the court, for whatever reason, decides he is released, this is just further evidence that at the very least the petition needs to be filed related to involuntary hospitalization prior to his release. So other than that, Your Honor, I rely on my motion.
Okay, I think the law is pretty clear that the court can't grant a PR bond for the reasons stated, and that being that the forensic center has not engaged in any treatment of Mr. Broker in an attempt to return him to competency. So the court's going to deny any kind of bond for that reason. However, totally agree with you. I think the forensic center is finding that he's incompetent, but could be restored. Then he needs to be transferred to the forensic center for treatment to determine whether or not it can be restored. So this isn't really a legal remedy, but the court is going to make written inquiry to the forensic center about the status of his case, when we can expect him to be transported there for treatment. I'll copy counsel on that in the file as well, so there's a record that the court's made that inquiry. We'll see what the forensic center says, and we'll go from there. But I think inquiries, I think Mr. Seeger's point that he needs treatment is correct, and I think inquiries at this point need to be made as to why that hasn't occurred yet. So
Yeah.
The court will do that before the end of the week, and again, counsel will get copies of that letter as well as any response from the forensic center.
Thank you.
Okay. Thank you. That's all for the court's morning docket. The court will be in recess until 1:30.